If you own an AR-15, an AK-47, or any similar semi-automatic rifle, 9 states are about to make you a felon in 2026. We're talking 10 years in prison and $10,000 fines just for possession. Some of these bans take effect in just weeks. And if you think you're safe because you bought your rifle legally years ago, think again. Several of these states are eliminating grandfathering protections, which means even guns you've owned for decades could suddenly make you a criminal. I'm going to walk you through all 9 states, tell you exactly what's banned, when these laws take effect, what the penalties are, and most importantly, what you need to do right now to stay legal. Because here's the truth. Ignorance of the law is not a defense. If you get caught with a banned firearm after these effective dates, you're looking at felony charges, prison time, and losing your Second Amendment rights permanently. Let's start with the 2 newest states joining this list because these are the ones catching gun owners completely off guard. Number 1, Rhode Island. Limited grandfathering with severe restrictions. Rhode Island just passed one of the most comprehensive assault weapon bans in the country, and it takes effect July 1st, 2026. That's just 7 months away. This isn't some vague law with loopholes. This is a complete prohibition on manufacture, sale, purchase, and transfer of what Rhode Island defines as assault weapons. So what exactly is banned? Any semi-automatic rifle with a detachable magazine that has one or more of these features. A folding or telescoping stock, a pistol grip that protrudes conspicuously beneath the action of the weapon, a bayonet mount, a flash suppressor or threaded barrel designed to accommodate one, or a grenade launcher. The same goes for semi-automatic shotguns with folding stocks, pistol grips, or fixed magazines holding more than 5 rounds. Here's where it gets serious. The penalties are up to 10 years in prison and a $10,000 fine. This is a felony conviction we're talking about. That means losing your right to vote, losing your right to own any firearms ever again, and having a permanent criminal record that affects employment, housing, and everything else. Now, Rhode Island does have grandfathering, but it's extremely restrictive. If you lawfully own one of these firearms before July 1st, 2026, you can keep it. But here's the catch. You can only possess it at your home, your place of business, on land you own, at a licensed shooting range, or while transporting it directly between these locations in a locked container. You cannot carry it anywhere else. You cannot sell it to anyone in Rhode Island. You cannot transfer it to anyone in Rhode Island. You cannot give it to your kids when you die unless they live out of state. The only legal options for transfer are through a federally licensed firearms dealer to someone out of state, or surrendering it to law enforcement. And if you move to Rhode Island after July 1st, 2026, you cannot bring any grandfathered assault weapons with you. They become illegal the moment you cross the state line. If you live in Rhode Island, here's what you need to do right now. First, make an inventory of every semi-automatic firearm you own. Check each one against the banned features list. If you have any that meet the definition, understand that after July 1st, 2026, your possession rights are severely limited. You cannot take these firearms hunting on public land. You cannot bring them to informal shooting spots. You cannot lend them to friends. Any possession outside your home, business, owned land, or licensed range is a felony. If you're planning to move out of Rhode Island in the next few years, you can take your grandfathered weapons with you. But if you're staying in Rhode Island long-term, think carefully about whether the restricted possession rights are worth keeping these firearms. Your alternative is to sell them to someone in a free state before July 1st, or transfer them to family members who live out of state. Number 2, Colorado. New purchase barriers, not a ban. Colorado is the second state implementing major new restrictions in 2026. And this one surprised a lot of gun owners because Colorado has traditionally been more gun-friendly than coastal states. But here's what's actually happening. Colorado is not banning assault weapons. Instead, on August 1st, 2026, Colorado is requiring a firearm safety course eligibility card for anyone who wants to purchase a semi-automatic firearm with a detachable magazine. This is critical to understand. If you already owned semi-automatic firearms before August 1st, 2026, you can keep them. There's no registration requirement. There's no surrender requirement. There's no restricted possession like Rhode Island. Your existing guns are completely exempt from this new law. But if you want to buy a new semi-automatic rifle or pistol after August 1st, 2026, you have to jump through significant hoops. You must complete a state-approved firearm safety course that includes live fire training, legal instruction, and safe storage protocols. You must pass a background check to get the eligibility card. The card costs money. The course costs money. And the card is only valid for 5 years before you have to renew it. Even after you get the eligibility card, you still have to pass the federal background check when you actually purchase the firearm, and you still have to wait through Colorado's 3-day waiting period. So, we're talking about weeks or months of process just to buy a single semi-automatic firearm. Colorado is also tightening restrictions on transfers. Starting August 1st, 2026, all private party transfers of semi-automatic firearms must go through a licensed dealer with a full background check. No more selling to your neighbor or giving a rifle to your adult son without involving an FFL. Violations are a Class 2 misdemeanor for first offenses, but repeat violations become felonies. If you live in Colorado, here's your action plan. If you're planning to buy any semi-automatic firearms in the next few years, do it before August 1st, 2026. After that date, you'll need to complete the entire eligibility card process first, which adds significant time and expense. If you already own semi-automatic firearms, you're fine. Keep them, use them, enjoy them. The new law doesn't affect your existing guns at all. But if you're thinking about private sales in the future, understand that after August 1st, 2026, every single transfer must go through an FFL with a background check. Plan accordingly. Document your current inventory so you can prove you own these firearms before the new law took effect. Number 3. California tightening an already strict system. California already has some of the strictest gun laws in the nation, but they're adding more restrictions effective July 1st, 2026. Assembly Bill 1127 specifically targets semi-automatic pistols that can be converted to fire automatically. This sounds narrow, but the definition is broad enough to catch a lot of firearms that gun owners wouldn't typically think of as convertible. The new law bans licensed dealers from selling any semi-automatic pistol that can be converted to shoot automatically without requiring replacement of major component parts. The Attorney General gets to determine which pistols meet this definition, and they're publishing a list. Penalties for dealers who violate this are up to $10,000 in civil fines plus potential criminal prosecution. For gun owners, this means the roster of handguns legal to purchase in California is shrinking even further. If you own pistols that end up on the ban list, you can keep them under California's existing grandfathering rules, but you cannot sell them to anyone else in California. Your only option for transfer is out of state or to law enforcement. California gun owners need to check the Attorney General's website regularly after January 2026 to see which pistols are being added to the banned list. If you own any of those models and you're thinking about selling, you need to do it before July 1st, 2026. After that date, your options are extremely limited. Now let's talk about the 6 states that already have assault weapon bans in place, but are ramping up enforcement or expanding definitions in 2026. Number 4. New York. The SAFE Act gets stricter. New York's SAFE Act has been in effect since 2013, but 2026 brings increased enforcement funding and new registration requirements. The state legislature allocated an additional $15 million specifically for assault weapon enforcement, which means more investigators, more prosecutions, and more aggressive enforcement of existing laws. Under the SAFE Act, it's illegal to possess any semi-automatic rifle with a detachable magazine that has one or more military features: pistol grip, folding or telescoping stock, thumbhole stock, second-hand grip, bayonet mount, flash suppressor, muzzle brake or compensator, or grenade launcher. It's also illegal to possess any semi-automatic shotgun with one or more of these features or any semi-automatic pistol with a detachable magazine and one or more military features. The penalties are serious. Possession of an assault weapon in New York is a Class D felony punishable by up to 7 years in prison. And here's what's changing in 2026. New York is implementing a new registration system for grandfathered assault weapons. If you owned an assault weapon before the SAFE Act and registered it, you now have to re-register it in the new system by June 30th, 2026. Failure to re-register converts your legal grandfathered weapon into an illegal weapon overnight. New York gun owners need to check their registration status immediately. If you registered an assault weapon back in 2013 or 2014, you must re-register it in 2026. The state is not sending out reminders. It's your responsibility to know about this requirement and comply. If you miss the deadline, you're committing a felony just by continuing to possess a weapon you legally registered years ago. Here's where gun owners are getting arrested right now. Number 5, New Jersey. Expanding this substantially identical list. New Jersey has had an assault weapon ban since 1990, but the state takes a unique approach. Instead of just banning specific features, New Jersey bans specific named firearms and then bans anything substantially identical to those named weapons. In 2026, the Attorney General is expanding that substantially identical list significantly. This is dangerous for gun owners because you might own a rifle that was perfectly legal when you bought it. But if the Attorney General decides it's substantially identical to a banned weapon, you're suddenly in possession of an illegal firearm. And the penalties in New Jersey are harsh. Possession of an assault weapon is a crime of the 3rd degree, punishable by 3 to 5 years in prison, and fines up to $15,000. New Jersey's 2026 expansion focuses on what they call copycat weapons. These are firearms that manufacturers designed to get around the original ban by making minor modifications to banned models. The Attorney General is publishing a new list in early 2026 that will include dozens of additional models considered substantially identical to banned weapons. If you live in New Jersey, you need to monitor the Attorney General's website starting in January 2026. When that new list comes out, you need to immediately check whether any of your firearms are on it. If they are, you have a very short window to either transfer them out of state or surrender them to law enforcement. New Jersey does not grandfather newly banned weapons. Once they're on the list, possession becomes illegal immediately. Number 6, Massachusetts, the copycat crackdown. Massachusetts takes the copycat concept even further than New Jersey. Under Massachusetts law, it's illegal to possess any weapon that's a copy or duplicate of a banned assault weapon, even if it doesn't have the specific features that define an assault weapon. Under the statute, the Attorney General has the authority to determine what constitutes a copy or duplicate, and in 2026, they're conducting a major enforcement crackdown. Massachusetts is specifically targeting what they call feature-compliant rifles. These are AR-15 and AK-47 style rifles that manufacturers modified to remove the features that technically make them assault weapons under Massachusetts law. Gun owners thought these were legal, but the Attorney General's office is now saying that if a rifle operates similarly to a banned weapon, has the same basic design, and fires the same ammunition, it's a copy or duplicate, regardless of whether it has a pistol grip or folding stock. This single mistake cost 200+ gun owners their freedom in 2025. The penalties in Massachusetts are severe. Possession of an assault weapon is a felony with mandatory minimum sentences. The first offense is at least 1 year in prison. The second offense is at least 5 years. And Massachusetts does not have a grandfathering clause for weapons the Attorney General newly designates as copies or duplicates. This is creating panic among Massachusetts gun owners, because thousands of people own feature-compliant AR-15 and AK-47s that they bought legally from licensed dealers who assured them these rifles were Massachusetts compliant. Now the state is saying those rifles were never legal in the first place. If you live in Massachusetts and own any AR-15 or AK-47 style rifle, even a feature-compliant version, you are at serious risk. The Attorney General's office has announced they will be conducting compliance checks in 2026, working with local police departments to identify gun owners who possess what they consider copycat weapons. Here's what Massachusetts gun owners need to do immediately. First, Consult with a Massachusetts firearms attorney who specializes in assault weapon law. Do not rely on what the gun store told you when you bought the rifle. Do not rely on internet forums. Get professional legal advice specific to your exact firearm model. Second, if your attorney advises that your rifle could be considered a copycat, you have three options. Modify it to a clearly non-AR/AK configuration, which may require significant gunsmithing, transfer it out of state to a family member or through an FFL, or surrender it to law enforcement. Do not wait for the state to come knocking. Proactive compliance is your best protection. Third, document everything. Keep your purchase receipts showing you bought from a licensed dealer. Keep any documentation showing the dealer represented the firearm as Massachusetts compliant. If you do face charges, this documentation could be critical to your defense. Number 7. Connecticut post-Sandy Hook enforcement intensifies. Connecticut's assault weapon ban has been in place since 2013, passed after the Sandy Hook tragedy. The law requires registration of all grandfathered assault weapons, and in 2026, Connecticut is conducting its first comprehensive audit of those registrations. Connecticut defines assault weapons similarly to other northeastern states. Semi-automatic rifles with detachable magazines and military features like pistol grips, folding stocks, flash suppressors, or grenade launchers. The penalties are up to 5 years in prison and $5,000 fines. Here's what's changing in 2026. Connecticut is cross-referencing assault weapon registrations with firearms purchase records to identify gun owners who should have registered weapons, but didn't. If you bought an AR-15 in Connecticut before 2013 but never registered it, the state knows. They have the 4,473 forms from your dealer. They have the background check records. And in 2026, they're using that data to find unregistered weapons. Connecticut is also implementing new storage requirements for grandfathered assault weapons. Starting April 1, 2026, all registered assault weapons must be stored in a locked safe or with a trigger lock when not in use. Failure to properly store is a separate criminal offense, even if you're otherwise in compliance with registration. If you live in Connecticut and own a grandfathered assault weapon, verify your registration status immediately. Log into the Connecticut State Police Special Licensing and Firearms Unit portal and confirm your weapon is properly registered. If it's not, you need to speak with a Connecticut firearms attorney right away about your options. If your assault weapon is registered, make sure you have compliant storage. A basic gun safe or trigger lock will satisfy the requirement, but you must be able to prove compliance if questioned. Keep receipts for your safe or locks. Number 8. Maryland. The banned firearms list expands. Maryland has prohibited assault weapons since 2013, but unlike other states that use feature tests, Maryland bans specific firearms by name. The law lists dozens of specific makes and models that are illegal to possess, manufacture, sell, or transfer. In 2026, Maryland is adding 37 new firearms to the banned list. These are mostly newer models that manufacturers released after 2013, designed to circumvent the original ban. The expanded list takes effect October 1, 2026. Maryland's penalties are up to 3 years in prison and $5,000 fines for first offense. The second offense jumps to 10 years in prison, and Maryland does not grandfather newly banned weapons. When a firearm gets added to the banned list, you have 90 days to either transfer it out of state or surrender it to law enforcement. After that 90-day window, possession becomes a felony. The 2026 expansion specifically targets pistol-caliber carbines, AR-15 pistols with stabilizing braces, and certain semi-automatic shotguns. If you own any of these categories in Maryland, you need to check the updated ban list as soon as it's published in July 2026. Here's the critical timeline for Maryland gun owners. The new ban list will be published July 1, 2026. The ban takes effect October 1, 2026. That gives you exactly 90 days to transfer or surrender any newly banned firearms. Do not wait until last week. FFLs will be overwhelmed with transfer requests. Out-of-state buyers will be harder to find. Start planning now. If you own firearms that might be on the new ban list, Identify potential buyers in free states now. Reach out to family members who live in states without assault weapon bans. Research FFLs who handle out-of-state transfers. Have a plan ready so you can execute quickly when the list drops. Number 9. Washington. Universal background checks and storage requirements. Washington state has taken a different approach than the other states we've discussed. Instead of banning assault weapons outright, Washington has implemented a series of restrictions that make ownership increasingly difficult and legally risky. In 2026, Washington is implementing two major changes. First, all semi-automatic rifle purchases now require completion of a state-approved firearm safety training course. This is similar to Colorado's system, but even more restrictive. The course must be completed within 5 years before purchase, must include live fire training, and must be taught by a certified instructor. Second, Washington is implementing strict storage requirements with criminal penalties. Starting January 1, 2026, if you own any semi-automatic rifle, you must store it in a locked safe or with a trigger lock whenever it's not under your immediate control. If someone steals your rifle because you didn't properly secure it and they use it in a crime, you can be charged with community endangerment. That's up to 1 year in jail and $5,000 fines. Washington is also expanding its extreme risk protection order system in 2026. Law enforcement, family members, and even roommates can petition a court to temporarily remove your firearms if they believe you're a danger to yourself or others. The standard of proof is low, and you can lose your guns for up to 1 year based solely on someone's statement that they're concerned about your mental state. If you live in Washington, here's your action plan. First, if you're planning to buy any semi-automatic rifles, complete an approved safety course before the end of 2025. That way, you're covered for 5 years. Second, invest in proper storage. A good gun safe isn't just smart practice, it's now legally required. Third, be aware of the extreme risk protection order system. If you're going through a divorce, having family conflicts, or dealing with mental health issues, understand that your firearms could be seized with minimal due process. Now, I know what you are thinking, why these laws might not survive. Now here's where things get interesting. Every single one of these state laws is being challenged in federal court right now. And after the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin in 2022, these challenges have real teeth. Bruin established a new test for gun laws. The government can't just say a law serves public safety and call it a day. They have to prove the law is consistent with America's historical tradition of firearms regulation. That means showing similar laws existed in 1791, when the Second Amendment was ratified, or at least in 1868 when the 14th Amendment was ratified. Here's the problem for these 9 states. There's no historical tradition of banning entire categories of commonly owned firearms. AR-15 and similar rifles are the most popular rifles in America. There are over 20 million of them in civilian hands. The Supreme Court has said repeatedly that the Second Amendment protects weapons in common use for lawful purposes. Several federal district courts have already issued preliminary injunctions blocking enforcement of assault weapon bans in other states. The Fourth Circuit Court of Appeals ruled Maryland's ban unconstitutional in 2023, though that decision is currently on appeal. The Ninth Circuit is hearing challenges to California's laws. The Second Circuit is reviewing New York's SAFE Act. Legal experts predict at least 2 of these cases will reach the Supreme Court by 2027. And based on the current court's composition and their reasoning in Bruin, there's a strong possibility they'll strike down assault weapon bans as unconstitutional. But here's what gun owners need to understand. Until the Supreme Court rules, these state laws remain in effect and enforceable. You cannot ignore them just because you think they're unconstitutional. You cannot refuse to comply because you believe they violate the Second Amendment. If you get caught with a banned firearm, you will be arrested, you will be prosecuted, and you will go to prison while your case works its way through the courts. The legal challenges are important. They might eventually invalidate these laws, but that could take years. In the meantime, you have to comply or face the consequences. Let me give you a clear action plan based on where you live. If you live in Rhode Island or Colorado, you have until mid-2026 before these laws take effect. Use that time wisely. Inventory your firearms. Identify which ones will be affected. If you're in Rhode Island and own assault weapons, decide whether the restricted possession rights are worth keeping them or whether you should transfer them out of state before July 1st. If you're in Colorado and planning to buy semi-automatic firearms, do it before August 1st to avoid the eligibility card requirement. If you live in California, New York, New Jersey, Massachusetts, Connecticut, Maryland, or Washington, these laws are already in effect or taking effect very soon. Your immediate priority is compliance verification. Check your registration status if your state requires it. Verify your firearms aren't on newly expanded banned lists. Ensure you have proper storage. Review the specific possession restrictions in your state for everyone in all 9 states. Document everything. Keep purchase receipts. Keep registration confirmations. Keep proof of proper storage. If you transfer firearms out of state, keep the FFL transfer records. If you surrender firearms to law enforcement, get a receipt. This documentation could be critical if you're ever questioned about compliance. Consider consulting with a firearms attorney in your state. Yes, it costs money, but it's a lot cheaper than a felony conviction. An attorney can review your specific situation, tell you exactly what you need to do to stay compliant, and help you navigate the complex and often contradictory requirements of these laws. Join or support Second Amendment advocacy organizations that are fighting these laws in court. Whether it's the Firearms Policy Coalition, the Second Amendment Foundation, or your state's gun rights organization, these groups need funding to continue the legal challenges. Your membership dues and donations directly support the lawsuits that might eventually overturn these bans. Look, I know this is a lot of information, and most of it is bad news, but here's why I made this video. Knowledge is your best defense. You cannot comply with laws you don't know about. You cannot protect yourself from prosecution if you don't understand what's illegal in your state. These laws are complex. They're changing rapidly and they carry severe penalties. A single mistake can cost you your freedom, your rights, and your future. But if you stay informed, if you verify your compliance, if you take the necessary steps to follow these laws, you can protect yourself. I don't like these laws. Many of you don't like these laws, but liking them or not liking them is irrelevant to their enforcement. As a responsible gun owner, your primary duty is to know the law and abide by it even when you disagree with it. Stay vigilant, stay informed, and stay safe. If you found this information helpful, please hit that like button. Subscribe to Guns Law Guide for more in-depth analysis of firearms laws, and leave a comment below telling me what gun laws in your state concern you the most. Your engagement helps us reach more gun owners who need this critical information. Thank you for watching, and I'll see you in the next video.